One important thing that we do at our firm is represent families who've had children hurt and who've hired us to represent them and recover for their injuries and losses. And in Texas and most states, anytime a child, a person less than 18 years of age, has an injury claim, because they are not adults and don't have the legal standing or capacity to make decisions for themselves, their parents or legal guardians are the ones who really have the right to bring the injury claim on their behalf. And representing injured children is a very important part of our practice. And there is a process to ensure that any settlement for a child is, number one, fair, two, in their best interest, and most importantly, three, that the money really gets to them. We've all heard stories about how parents or legal guardians who have children with a lot of money for whatever reason, including settlements, mishandle it, and the kids, grow up and realize their money that should have been there is no longer there. So what happens after a family has an injury to a child? They bring an injury claim, and either it's settled by agreement with the insurance company. How does that process work? Well, for every proposed settlement for an injured child that has a value of more than a few $1,000s, most insurance companies who are paying the settlement and the lawyers representing the family benefit from what sometimes we call a friendly lawsuit, meaning once a settlement agreement is reached in principle, a lawsuit is filed where the parents, as next friends or representative of the child, sue the other driver. It's typically a lawsuit that's paid for completely by the defense, the insurance company, and the judge who gets that case appoints an attorney called an attorney ad litem. And that attorney's job is to meet with the family, learn about what happened in the injury case, learn about the settlement, and make sure that it is fair, in the child's best interest, and ultimately that the money that's being paid is maximized for the child's benefit. Most of the time, if the settlement is, let's say, under $50,000, the money that is the child's share of the settlement that the court approves gets put in the court's registry, which is essentially a savings account. And once the child turns 18 years old, they can show up, fill out a form, and they get their settlement money plus a little bit of interest that it's earned over the time it's been on deposit. The other option is when there's a larger amount, oftentimes that money, instead of going in the court's bank account, can be invested into a structured settlement that will pay a bigger amount, not just at age 18, but for whatever period of time is in the child's best interest. So the guardian ad litem's job is to really understand not only what happened and how much money is being paid, but then to come up with the best strategy to maximize those dollars over the course of the child's life. So one thing that we often like to do is have a structured settlement that can start paying money at 18, but maybe have annual payments for college years. So there's some college money, but you can set it up however you want. The important part of the process for you to understand is it's really being done for all the right reasons. Having the court understand what the case is about, where the money is coming from, make sure that the amount that's being paid is fair and that those dollars are going to be used for the child's best interest is very important. And the fact that it doesn't cost anything to go through this process, it's paid for by the other side, really should give you peace of mind. As hard as it is to have gone through the experience of having a child injured, The court approval process may seem like an extra burden, but it really is important. It ensures that the money that's being paid is fair. It ensures that the money that is being recovered is being protected for the child in their future. And the end result is you have a judge approve and endorse the settlement that you've reached for your child. So it really is in the best interest of everybody involved. At our firm, we know how difficult it is to have gone through something like that. But understanding how we conclude those cases and have a judge approve the settlement is really that extra peace of mind, not only for the parents, but for the child down the road. And it ensures that they get as much benefit from the settlement and that that money is protected and available to them when they need it most.